General nature of a partnership. Partnership is the relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. Persons who have entered into partnership with one another are called individually partners, and collectively a firm, and the name under which their business is carried on is called the firm name. Elements of partnership. Association of two or more persons. Partnership is an association of two or more persons. Again, only persons recognized by law can enter into an agreement of partnership. Therefore, a firm, since it is not a person recognized in the eyes of law, cannot be a partner. Agreement. It may be observed that partnership must be the result of an agreement between two or more persons. There must be an agreement entered into by all the persons concerned. Business. First, there must exist a business. For the purpose, the term business includes every trade, occupation and profession. Secondly, the motive of the business is the acquisition of gains, which leads to the formation of partnership. Agreement to share profits. The sharing of profits is an essential feature of partnership. There can be no partnership where only one of the partners is entitled to the whole of the profits of the business. Partners must agree to share the profits in any manner they choose. Business carried on by all or any of them acting for all. The business must be carried on by all the partners or by any one or more of the partners acting for all. In other words, there should be a binding contract of mutual agency between the partners. Partnership deed. Mode of determining existence of partnership. In determining whether a group of persons is or is not a firm, or whether a person is or not a partner in a firm, regard shall be had to the real relation between the parties, as shown by all relevant facts taken together. Partnership deed. Partnership is the result of an agreement. No particular formalities are required for an agreement of partnership. But it is desirable to have the partnership agreement in writing to avoid future disputes. The document in writing containing the various terms and conditions as to the relationship of the partners to each other is called the partnership deed. Information contained in partnership deed. Name of the partnership firm, names of all the partners, nature and place of the business of the firm, date of commencement of partnership, duration of the partnership firm, capital contribution, profit sharing ratio, admission and retirement of a partner, rates of interest, related provisions. True test of partnership. Agreement. Partnership is created by agreement and not by status. The relation of partnership arises from contract and not from status, and in particular, the members of a Hindu undivided family carrying on a family business as such are not partners in such business. Sharing of profit. The sharing of profits or of gross returns arising from property by persons holding a joint or common interest in that property does not of itself make such persons partners. Where there is an express agreement between partners to share the profit of a business and the business is being carried on by all or any of them acting for all, there will be no difficulty. Agency. Existence of mutual agency, which is the cardinal principle of partnership law, is very much helpful in reaching a conclusion in this regard. Each partner carrying on the business is the principal as well as an agent of other partners. Kinds of partnership. Partnership at will. According to Section 7 of the Act, partnership at will is a partnership when no fixed period has been agreed upon for the duration of the partnership, and there is no provision made as to the determination of the partnership. Partnership for a fixed period. Where a provision is made by a contract for the duration of the partnership, the partnership is called partnership for a fixed period. It is a partnership created for a particular period of time. Such a partnership comes to an end on the expiry of the fixed period. Particular partnership. A partnership may be organized for the prosecution of a single adventure as well as for the conduct of a continuous business. Where a person becomes a partner with another person in any particular adventure or undertaking, the partnership is called particular partnership. General partnership. Where a partnership is constituted with respect to the business in general, it is called a general partnership. In the case of a particular partnership, the liability of the partners extends only to that particular adventure or undertaking, but it is not so in the case of general partnership. Types of partners. Active or actual or ostensible partner. He acts as an agent of other partners for all acts done in the ordinary course of business. In the event of his retirement, he must give a public notice in order to absolve himself of liabilities for acts of other partners done after his retirement. Sleeping or dormant partner. They share profits and losses and are liable to the third parties for all acts of the firm. They are, however, not required to give public notice of their retirement from the firm. They are called as sleeping or dormant partners. Nominal partner. A person who lends his name to the firm, without having any real interest in it, is called a nominal partner. He is not entitled to share the profits of the firm. Neither he invests in the firm nor takes part in the conduct of the business. He is, however, liable to third parties for all acts of the firm. Types of partners. Partner in profits only. A partner who is entitled to share the profits only without being liable for the losses is known as the partner for profits only and also liable to the third parties for all acts of the profits only. Incoming partners. A person who is admitted as a partners into an already existing firm with the consent of all the existing partners is called as incoming partner. Such a partner is not liable for any act of the firm done before his admission as a partner. Outgoing partner. A partner who leaves a firm in which the rest of the partners continue to carry on business is called a retiring or outgoing partner. Such a partner remains liable to third parties for all acts of the firm until public notice is given of his retirement. Partner by holding out. Partnership by holding out is also known as partnership by estoppel. Where a man holds himself out as a partner, or allows others to do it, he is then stopped from denying the character he has assumed and upon the faith of which creditors may be presumed to have acted.